Picture this. A woman plants a bomb in a crowded public place, sets the timer, and walks away. By sheer luck the police find it and defuse it minutes before it would have gone off. Nobody dies. Nothing burns. The harm the criminal law normally punishes, the death, the damage, simply never happened. So ask yourself the lawyer's question, is she guilty of anything at all? Your gut says yes, obviously. But notice why your gut is uneasy. Snyman puts it exactly, the only difference between this woman and a mass murderer was a factor entirely beyond her control, the police happening to find the device. Her intention was identical. Her dangerousness was identical. Her need to be stopped and reformed was identical. The only thing missing was the explosion. Today's whole topic is the law's answer to that unease, the doctrine of inchoate crimes, crimes that punish the reaching for harm even when the harm never arrives. The word inchoate comes from a Latin root meaning just begun or not yet fully developed. The study guide calls them incomplete crimes, and the two words mean the same thing. The UNAM study guide names exactly three: attempt, conspiracy, and incitement. Here is the deep contrast to lock in first, because every exam answer on this topic turns on it. Ordinary crimes are what the course material call consequence-oriented. Murder needs a death, theft needs a thing taken, arson needs something burnt. The crime is defined by its result. Inchoate crimes are the mirror image, they rest on the non-completion of the intended consequence. The law reaches backwards in time, grabbing the wrongdo before the harm, sometimes instead of the harm. But why would a system built on punishing harm punish people who have caused none? Snyman is precise here, and this is a high-value exam point. If you apply the retributive theory of punishment, punishment as payment of a debt for harm done, inchoate crimes make no sense, because no harm has yet been done, there is no debt. The justification must come instead from the relative theories, prevention and reformation. 2 reasons. First, prevention and the maintenance of law and order. The police can only protect the community if they may step in when they see people preparing to commit crimes, rather than being forced to stand by, powerless, until the harm is complete. Second, reformation. A person who plants a bomb that fails to explode is exactly as dangerous, and exactly as much in need of reform, as one whose bomb explodes. The difference between them often turns on luck beyond the wrongdoer's control. So the law treats them alike. Write that down as the rationale for the whole topic. Inchoate crimes are justified by the preventive and reformative theories, not the retributive theory. Now the first and most important inchoate crime, attempt. Start with the definition the study guide gives you, because that is the one the exam follows. An attempt is an unlawful and intentional act by which a person, with the intention to commit a specific crime, begins the execution of that crime but does not complete it. The course material confirm the headline rule for Namibia: a person may be held liable even for an attempt to commit a crime. Here is the conceptual heart of attempt, and Snyman states it as a first principle: mere intention to commit a crime is not punishable. Nobody can be punished for her thoughts. A wicked plan locked inside your skull is not a crime. The law only bites once your resolve manifests itself in outward conduct. But not every outward act is enough either. Snyman gives the 2 famous examples. If you mean to commit murder, you are not guilty of attempted murder the moment you buy the revolver. If you mean to commit arson, you are not guilty the moment you buy a box of matches. So picture a road. At one end sits the bare evil thought, not punishable. At the far end sits the completed crime, punishable as the full offense. Somewhere along that road is a boundary line, and the accused becomes guilty of attempt the moment she crosses it. Snyman calls locating that boundary one of the most difficult problems in criminal law. A test that works neatly on one set of facts often fails on the next. The entire law of attempt is the search for where that line falls. So where is the line? The criterion our court settled on, and the one you must name in the exam, is the distinction between acts of preparation and acts of execution, also called acts of consummation. If what the accused did was merely preparing for the crime, there is no attempt yet. If her acts went beyond preparation and became acts of execution, actually carrying the crime out, she is guilty of attempt. The study guide states the rule crisply: only the acts of execution are punished in criminal law. The classic formulation of the threshold comes from R.V. Novo 1921 AD for 85. The Act, said Novo, must reach far enough towards the accomplishment of the desired result to amount to the commencement of the consummation. Sit with that phrase, commencement of the consummation, because it is the money phrase for this topic. The leading case, the one both the study guide and Snyman crown as authoritative, is R.V. Scoombie 1945 AD 541. Scoombie went to a shop in the early hours of the morning, poured petrol around and underneath the door so it ran inside, and placed a tin of inflammable material against the door, and at that very moment a policeman appeared. Was that mere preparation, or had he commenced the consummation? The appellate division upheld his conviction for attempted arson and authoritatively confirmed that the test is to distinguish acts of preparation from acts of consummation. Pouring the petrol and positioning the firearm was execution, not mere preparation. The lesson: get close enough to doing the deed, not just equipping yourself for it, and you have attempted it. Now, the honest part, and examiners reward students who show they know the test's weakness. Snyman records that the Scoombie test has been criticized for vagueness, applying it means distinguishing, in his memorable phrase, the end of the beginning from the beginning of the end. There is no formula that decides every case, each set of facts must be judged on its own merits, with what one case called a pragmatic and common-sense approach. Abstract tests blur, examples sharpen. Snyman lines up the case law on each side of the boundary, and walking through them trains your intuition for the exam problem question. On the preparation side, where the accused is acquitted of attempt, the courts have placed a person who has merely prepared the poison she means to administer later, caught before she gives it to anyone, a would-be car thief who walks late at night with a screwdriver up to a car, shines a torch on it, but is grabbed before doing anything to the car, a burglar who has only opened cupboards and thrown the contents on the floor when caught, and one who has only moved the curtains outside a window before being apprehended. All of those are getting ready, not yet carrying out. On the execution side, where the accused is convicted of attempt, sit a prisoner who breaks the glass and frame of her cell window trying to escape, a housebreaker who puts the key into the door, the arsonist who arranges inflammable materials and fuel inside the building, that is Scoombie, a person trying to do business in a forbidden trade who posts a letter containing the offer, and, important and often examined, a man who, trying to rape Y, has so far only assaulted her, that assault is already an act of execution of the rape, hence attempted rape. Notice the pattern: once the accused lays hands on the very object or victim of the crime, or sets in motion the final causal chain, she has crossed from preparing into executing. And there is no rule that the accused must take the last possible step before she is guilty. If she plans to poison Y slowly over weeks, she is guilty of attempt on the very first occasion she puts poison in the food. The line is commencement of the consummation, not its completion. Both the study guide and the course material split attempt into two factual shapes, and Scoombie itself supplies the definitions, so quote them. A completed attempt is one in which the wrongdoer, intending to commit a crime, has done everything which she set out to do, but has failed in her purpose, whether through lack of skill, lack of foresight, the existence of some unexpected obstacle, or otherwise. The assassin who fires and misses. The poisoner whose victim is saved by timely medical treatment. She did all of it, the result simply didn't come. An interrupted, or uncompleted, attempt is one in which the wrongdoer has not completed all she set out to do, because the completion of her unlawful acts has been prevented by the intervention of some outside agency. The arsonist caught mid-pour by the policeman, as in Scoombie. The thief grabbed before she opens the safe. The course material add a practical procedural twist worth a mark. For a completed attempt the court will not look closely at proximity, the accused plainly went all the way, so there is nothing to argue about. But for an incomplete or interrupted attempt the court will scrutinize the acts closely, applying the Scoombie preparation versus execution test, precisely because the question of whether she crossed the line is live. Two cases make the completed attempt concrete, and one of them is Namibian, so it is gold for your answer. R.V. Hlatwayo 1933, the accused, a servant, put caustic soda into her employer's porridge intending to poison them. Another servant saw the porridge discolor, realized what was happening, and the accused, now exposed, threw the poisoned porridge away. She never killed anyone. Yet the court held her attempt was definitely complete, she had done everything on her part to commit the crime, and her later disposal of the porridge did not undo it. Convicted of attempted murder. Hold Hlatwayo in your mind, it returns in the voluntary withdrawal scene, because it is also the leading authority there, and the reason it returns is subtle. Now the Namibian authority the study guide gives for an uncompleted attempt, Tjiveze v. the State, CA 110, 2002, 2012 and 84. The accused found it physically impossible to insert his penis into the vagina of the complainant, a minor girl. On appeal the court replaced his rape conviction with a conviction of attempted rape, because the defining act of rape, penetration, was never completed, but he had unquestionably commenced the consummation by assaulting and attempting to penetrate her. Tjiveze is your homegrown anchor, use it to show attempt operating in a Namibian court. Here is the question every student wants answered. The accused changes her mind and pulls back, is she off the hook? The study guide poses it directly and answers it with a clean rule that turns entirely on timing, and timing measured against the line we drew earlier. The decisive question is, when did she decide to abandon the criminal project? If she changes her mind before her act amounts in law to an attempt, that is, while she is still merely preparing, she is not guilty of attempt. There was no attempt to withdraw from. But if she changes her mind after her act has already crossed into the commencement of the consummation, once it already is an attempt, she is guilty regardless of her change of heart. Voluntary withdrawal at that stage is no defense. Incitement states the same rule and supplies the authority. Voluntary withdrawal after the commencement of the consummation is no defense, the accused is guilty of attempt. The leading case is Hlatwayo again. And here Incitement makes a sharp, examinable observation. Hlatwayo is cited for the withdrawal is no defense rule, but it is poor authority for it, because on the facts there was no genuine voluntary withdrawal at all. The accused threw the porridge away only because other servants had caught her out. She abandoned the plan under exposure, not out of a free change of heart. So the rule survives, but its flagship case doesn't cleanly illustrate it, a perfect critically discussed point. Our courts inherited the English hardline rule, no defense after consummation begins. Incitement criticizes this and prefers the continental approach for the case of genuine withdrawal before any harm is done, but you must state the current law first, then offer the criticism. Now a genuinely mind-bending corner, and a favorite of examiners because it separates the students who understand attempt from those who merely memorized it. What if the crime the accused was trying to commit was impossible to complete? The pickpocket reaches into an empty pocket. The poisoner uses a substance that is harmless. The would-be murderer shoots at a man who was already dead. Can you attempt the impossible? The Namibian and South African answer, settled by the Appellate Division in R. v. Davies 1956 3 SA 52A, is yes, attempts to commit the impossible are punishable. In Davies the accused tried to procure an abortion, but at the time of her attempt the fetus was already dead. The court convicted her of attempt anyway, and adopted a frankly subjective approach. You judge the accused on the facts as she believed them to be. She believed she was aborting a live fetus, she did acts intending that result, that is attempt. Incitement categorizes three kinds of impossibility. First, impossibility of the means, the accused uses the wrong instrument. Second, impossibility of the object, the target isn't what the definition requires. Third, impossibility of the subject, the accused lacks a quality the crime's definition demands. Now the crucial line you must draw, factual impossibility versus legal impossibility. Everything above is factual impossibility, the accused was mistaken about the facts, and she is guilty. But there is a category that is not punishable, the putative crime, which is legal impossibility. A putative crime is conduct the accused wrongly believes is a crime but which the law does not criminalize at all. Inciment's example, adultery is not a crime in our law. If a person commits adultery believing it to be a crime, she is not guilty of attempted adultery, because there is no such crime to attempt. To convict her would let people invent crimes by their own mistaken beliefs, smashing the principle of legality, nullum crimen sine lege. So the master distinction is this: mistake about the facts leads to attempt to commit the impossible, guilty on Davies; mistake about the law, believing a non-crime to be a crime, leads to a putative crime, not guilty. And the sensible outer limit, the superstitious attempt. The person who tries to kill an enemy by prayer or witchcraft, where an ordinary person would see no danger to anyone, is not punishable. 2 tidy points that round out attempt. First, some crimes cannot be attempted at all. Snyman's neat example: you can attempt the crime of being in possession of a forbidden article like dagger, but you cannot attempt the crime of being found in possession, because to attempt that you would have to intend to be discovered by the police while committing the crime, which is nonsensical. More importantly for the exam, you cannot attempt a crime of negligence. There is no such thing as attempted culpable homicide. Why? Attempt requires intention to commit the crime, but culpable homicide is killing through negligence, not intention. You cannot intend to be negligent. As Snyman puts it, negligent attempt is notionally impossible. Second, the phrase in your outline, the successful attempt. What if the attempt actually works? The answer is the doctrine of merger. A successful attempt merges into the completed crime. If the assassin fires and the victim dies, you don't convict of attempted murder, the attempt is swallowed by the completed murder, and you charge murder. You can never be convicted of both the attempt and the completed crime arising from the same act. That would punish one wrong twice. What state of mind must the prosecution prove for attempt? Everyone agrees on the floor: attempt is an intentional crime, fault in the form of intention, dolus, never negligence. We just saw why. But on which form of intention suffices? Your 2 prescribed sources diverge, and a careful student flags it rather than papering over it. The UNAM study guide states firmly that attempt requires dolus directus, direct intention, reasoning that you cannot attempt to do something you did not mean to do. On that view, foresight of a possibility, dolus eventualis, is not enough for attempt. Snyman, by contrast, holds that intention in attempt bears the same meaning as intention to commit the completed crime, and dolus eventualis is therefore sufficient. These genuinely conflict. My advice for the exam: state the rule the study guide gives, dolus directus, because the exam follows the course outline and the study guide is the UNAM text. Then note that Snyman, the prescribed depth text, treats dolus eventualis as sufficient, and that the safer practice is to allege and prove direct intention. Verify which position the course endorses in lectures. If he follows Snyman, lead with dolus eventualis. Either way, show you know both. That is where the distinction level marks live. Move to the second inchoate crime, incitement, and immediately fix the Namibian terminology, because the course material flag it and it is an easy mark to lose. Namibian criminal law has no offence called abetment. That is an Indian or English textbook word. Namibia uses incitement or instigation. If you write abetment in a Namibian exam, you signal you've studied the wrong jurisdiction. The study guide's terminology box defines the players. The inciter is the one who reaches and seeks to influence the mind of another to commit a crime. The incitee is the person being encouraged. The definition to quote comes from the leading case, S. v. Nkosiyana 1966 for Essay 655a. Where Holmes J. said, an inciter is one who reaches and seeks to influence the mind of another to the commission of a crime. Plain English version, incitement is planting the seed of a crime in someone else's head, trying to turn their will toward committing it. Snyman defines it as unlawfully and intentionally influencing or encouraging another to commit a crime, and the study guide adds the wonderful phrase you should deploy: the means used to persuade are secondary, because the machinations of criminal ingenuity are common. The inciter's toolkit is enormous: suggestions, proposals, requests, commands, gestures, arguments, inducement, goading, bribery, persuasion, the arousal of cupidity, even a prostitute's bodily movement to solicit can be incitement. The form does not matter. What matters is that the inciter sought to influence the incitee's mind toward the crime. Let's get surgical about the requirements, because incitement problem questions live in the grey zone between urging a crime and just talking. No element of persuasion is required. Older cases thought you could only incite an unwilling person whose resistance you overcame, but Nkosiyana rejected that. So you can incite even someone already determined to commit the crime. Snyman's Latin tag is the omni modo facturus, one who is going to do it anyway. And if you incite Y and Y refuses, you are still guilty of incitement, because the crime is complete the moment you try. What does not count? Snyman draws the line carefully. It is not incitement merely to describe to Y the pros and cons of a possible crime, arouse Y's curiosity, arouse Y's greed, or merely express a wish, opinion or desire, saying it would be a good thing if Z died does not, beyond reasonable doubt, amount to trying to influence Y to kill Z. Creating a motive is not enough, you must actually seek to influence the will. Then the requirement with a name to drop, the concretization requirement. Excess words must not be too vague or equivocal, they must be concrete enough that Y knows what she is being incited to do. Two things must be specified, the type of crime, though X needn't use its formal legal name, and the victim or object, a specific person, or someone from a specifiable group. So commit crimes. Is not incitement, Y has no idea which crime or against whom. But X need not know the identity of those she incites. Incitement can be aimed at a crowd, in a speech, or in a pamphlet to unknown readers. One more limit, incitement by omission is not possible. Silently failing to talk someone out of a crime is not inciting it, unless X had a legal duty to act. Now the single most important and most counterintuitive rule about incitement, the one the study guide and slides both stress and the one examiners test relentlessly. Incitement is complete the instant the inciter reaches out to influence the incitee's mind. It does not matter what the incitee does next, or whether the incitee does anything at all. The study guide cites A v. Novo 1921 for the proposition that incitement is a crime whether or not the person incited is successful in committing the crime he was encouraged to commit. Snyman sharpens it. Incitement is a purely formally defined crime. No causal relationship between excess words and any later action by Y is required. Excess guilt does not depend on whether Y was actually influenced, whether Y agreed, whether Y took any step, or whether Y committed the crime. Whether Y was even susceptible to influence is irrelevant, and the proof of that is in Kosiana itself, where the man incited was a police trap who could never have been influenced, and the inciter was still convicted. So burn this in, the inciter is liable even if the incitee does nothing. The wrong of incitement is the reaching out, not the result. This is what makes it a true inchoate crime. Guilt attaches before, and independent of, any harm. But what if the incitee does go on to commit the crime? Then the picture shifts. If the incitement succeeds and the incitee commits the crime, the inciter is no longer charged with mere incitement, she is prosecuted as a co-perpetrator or an accomplice of the completed crime. Snyman confirms our courts say the Section 18 subsection 2 incitement charge ought to be used only when the incitement was unsuccessful. Once it succeeds, charge the substantive crime via participation. For refinements, your outline asks for by name. First, conditional incitement. What if the urging is subject to a condition? In S.V. Dick 1969 3 SA 267R, X asked Y to give Z a substance to win Z back, adding that if it failed, Y should kill Z, incitement subject to a condition. The court held conditional incitement is still punishable incitement, there, incitement to murder. Snyman's framing, X sows the seed and then loses control of events, her intention to incite is present as dolus eventualis. Modern version, demand the money, and if he refuses, beat it out of him, that is incitement to robbery. Second, incitement to commit the impossible. If X incites Y to pick a pocket X believes contains money, but it is empty, X still commits incitement to theft. The courts apply the same subjective approach as in attempts to the impossible. Judge it on the facts as X believed them. Third, the incitee must have criminal capacity. You cannot incite a person you know lacks criminal capacity, a young child or a mentally ill person, because you are not getting someone to commit a crime. But if that incapable person does the deed, X may be guilty as an indirect perpetrator, one who commits the crime through the instrumentality of another. Fourth, chain incitement. X may incite Y1 to go and incite Y2 to commit the crime. Snyman's example is a wife asking her son to find a hitman to kill her husband. The number of links in the chain makes no difference to excess liability. And for fault, intention only, never negligence, dolus eventualis suffices, and X must intend that Y2 will act with the intention to commit the crime. The third inchoate crime, conspiracy. The study guide's definition, an unlawful agreement between two or more persons to commit, procure, or assist in the commission of a crime. The course material put the punchline up front, where a group of conspirators agree to do an unlawful act. Under Namibian law they are penalized for the mere fact of their conspiracy, the agreement to do the unlawful act, even if nothing follows. So identify the unlawful element with care, because this is the examine point. The actus reus of conspiracy is the agreement itself. Not the planning, not the preparation, not the crime, the act of agreeing. Snyman, it is in the conclusion of the agreement itself that one finds the unlawful conduct. The phrase the courts use is there must be a meeting of minds. Crucially, two people merely sharing the same intention is not conspiracy. Snyman's vivid example, if X breaks into a house, and Y, completely unaware of X, breaks into the same house on the same night, neither is guilty of conspiracy, though both intend the identical crime. There must be an actual agreement between them. The agreement may be express or tacit, inferred from conduct, provided that inference is the only reasonable one, but mere knowledge of a conspiracy, or merely overhearing one, or merely being present while others conspire, is not enough to make you a party. You must, by word or conduct, make yourself a party to the agreement. And the timing rule that makes conspiracy a true inchoate crime: the crime is complete the moment agreement is reached. It is unnecessary to prove the commission of any further acts in execution of the conspiracy. 3 things to finish conspiracy. First, the Namibian framing. The course material present conspiracy in Namibia as restricted to agreements to commit crimes of a riotous nature, coups d'état and treason, and extending to offences touching the safety and security of the state, like terrorism and sabotage. Important nuance to flag: this restricted to riotous framing reflects the origin of the offence in the Riotous Assemblies Act, but Snyman is emphatic that the crime is not in fact limited to riotous assemblies. The statutory definition is wide enough to cover conspiracy to commit any crime. So in your answer, state the course's slide framing, then note that the prescribed text reads the offence far more broadly. The Namibian anchor the study guide gives is real and local. The cases arising from the August 1999 attempt to break the Caprivi, now Zambezi, region away from Namibia, the government of the Republic of Namibia v. Mwilima, S.V. Malumo, and S.V. Lizilai feature conspiracy prominently. Use the Caprivi cases as your Namibian illustration of conspiracy. Second, the intention required: 2 components, both needed. X must intend to conspire, to enter the agreement with another, and X must intend that the crime be committed. Mere knowledge that the article you sold will be used in a crime is not enough, there must be intention on both limbs. Third, withdrawal as a defense. The study guide states it plainly: an accused may successfully raise the defense that she withdrew from the commission of the crime. But pin the timing: exactly as with attempt, withdrawal can succeed only before the requirements of conspiracy are complete, that is, before the agreement is concluded. Once the meeting of minds has happened, the crime of conspiracy is already complete. An abandonment of the scheme after this stage is no defense. A whole scene on the statute, because your outline flags it and accuracy demands honesty here. In Snyman, the statutory home of 2 of our 3 inchoate crimes is Section 18 of the Riotous Assemblies Act 17 of 1956, a South African statute. Section 18 subsection 1 makes attempts to commit statutory crimes punishable, Section 18 subsection 2 paragraph A punishes conspiracy, and Section 18 subsection 2 paragraph B punishes incitement. In each, the stated maximum penalty is the same punishment as for actually committing the crime, though courts in practice impose less, because the inchoate wrongdoer is further from the completed harm. Here is the flag you must raise, and it earns credit because it shows jurisdictional care. That act is South African. Its operation in Namibia is not by direct enactment but by way of Article 66 of the Namibian Constitution, which continued in force the common law and statutory law that applied in Namibia immediately before independence. Verify before stating as settled Namibian law: first, whether the Riotous Assemblies Act was in force in South-West Africa at independence and survives; second, whether a Namibian statute now governs conspiracy and incitement. And one trap to avoid: the South African Constitutional Court in Economic Freedom Fighters v. Minister of Justice read the word serious into Section 18 subsection 2 paragraph B, so that incitement there now reaches only serious offences. That is a South African constitutional remedy and does not automatically bind Namibia. Do not state it as Namibian law without verification. Describe the Section 18 framework as Snyman gives it, attribute it correctly to the 1956 Act, and expressly flag that the Namibian statutory position needs confirmation. The study guide's final activity asks you to explain the relationship between attempt, conspiracy, and incitement, so close with how they interlock, because a synthesis paragraph lifts an answer. These are sometimes called double-inchoate crimes, and the study guide lists the workable combinations. Attempt to commit incitement is possible. Snyman's example is the inciting letter intercepted in the post before it reaches Y. X tried to incite but the message never landed, so it is attempted incitement. Incitement to commit attempt is possible. X hands Y a gun loaded with blanks that X knows about and tells Y to shoot Z. Y can only ever attempt murder, so X incites an attempt. Conspiracy to commit incitement is possible. And a single act of incitement may simultaneously be an attempt at the main crime, if X urges an already armed Z to kill Y while Z stands in Y's very presence. X's act is so close in time and place to the killing that it may itself qualify as an act of execution, hence attempt. But Snyman's sensible limit, attempt to attempt and conspire to conspire resist any logical demarcation from the single inchoate crime and are rejected. The unifying idea, the through line of the whole unit, the criminal law builds a series of tripwires in front of the completed crime. Conspiracy catches the agreement, incitement catches the urging, attempt catches the execution that fell short. Each is justified not by harm done but by danger posed, prevention and reformation, not retribution, and each lets the law, and the police, intervene before the harm arrives rather than after. Tie it together for the exam. Attempt, the accused began the execution of a specific crime but didn't complete it. The line between innocent preparation and punishable execution is the commencement of the consummation test from Scooby, phrased in novo. Distinguish completed from interrupted attempts. Voluntary withdrawal is no defense once consummation has begun, Hlatwayo, but remember its weakness as authority. Attempting the factually impossible is punishable on a subjective approach, Davies. The putative crime, legally impossible, believing a non-crime to be a crime, is not punishable, because of legality. Fault is intention, flag the study guide and Snyman split, dolus directus versus dolus eventualis, no attempt of negligence crimes. Incitement, reaching to influence another's mind to commit a crime in Kosiana, call it incitement or instigation, never abetment. It is complete the moment X tries, even if the incitee does nothing, novo, guilt held even where the incitee was a police trap, Nkosiana. The words must satisfy concretisation, specify the crime and the victim. Conditional incitement, Dick, and incitement to the impossible are punishable. If the incitement succeeds, the inciter is charged as a co-perpetrator or accomplice of the completed crime. Conspiracy, the agreement itself is the unlawful element, a meeting of minds between two or more, complete the moment agreement is reached, no further act needed, sharing the same intention is not enough. Withdrawal is a defense only before the agreement is complete. The course frames it around riotous and state security crimes, but Snyman reads it to cover any crime. Your Namibian illustration is the Caprivi secession litigation. And always, flag the statutory question. Conspiracy and incitement rest in Snyman on Section 18 of the Riotous Assemblies Act 17 of 1956, a South African act applying in Namibia through Article 66 inheritance, verify the precise Namibian position. That single act of jurisdictional honesty is the mark of a first-class Namibian criminal law answer.